Yeah. How good Mr. Judy Babai, Mr. Alex Uganda, Mr. Remy Bakena, Mr. Lester Nambi, Mr. George Musisi, Mr. Samuel Tabot, Miss or Mr. Willis, I remember Mrs. For the second respondent, we have Mr. Eric Saga. My oath for the petitioner, we have Kasa Kalule. He's appearing with the particular market. And Mr. Kimili we are ready to proceed. Yes, Mr. Alex, which team of Alex Uganda represents response by Remy.
My Lord, for the record, Alex Uganda once again. My Lord, in brief response to the preliminary issues raised, this court is faced with an appeal task in view of the High Court and the Court of Appeal decisions that were cited by our colleague for the petitioner. That is the Brandon case, the Nalukoola case, and the others. I will not quote the citation because it's already on record, which were decided by Imperium in light of the earlier decision of the Supreme Court of Uganda. And my Lord, I will also be specific. That is Bakaluba Mkasa versus Nambi Veti by JK, which my Lord laid down the principles of how courts should approach or treat recanting witnesses or affidavits, like in the instant case. My Lord, for brevity, this honorable court is not necessarily bound because the same were decided by Imperium.
What is the decision?
My Lord, I'm coming to the same. My Lord, that without prejudice, my Lord, to the foregoing. Without prejudice, my Lord, to the foregoing, our colleague will supply the principles in the authorities cited. Because in all those cases, for example, even Chintu Brandon versus William, that is election petition appeal number 64 of 2016, which I happen to argue on appeal, resulting into the decision cited. The question of recanting witnesses in all those authorities were not handled as preliminary issues. They were resolve in the final determination of the petition when court had the opportunity to scrutinize the various forms and versions of the affidavits, and court throughout all the authorities, both the High Court and the Court of Appeal, were following the precedent of Bakalwa Mukasa, which was stare decisis. And my Lord, I will submit that the prayer by the petitioner's counsel to expunge the three affidavits in question, that is of Ben Intale Mukasa, of Maumbe George William, and of Chemba Nathan Mwangis, before the same are even admitted into evidence, and court has had the opportunity to listen to them, will be leading this honorable court into a violation of the respondent and the three witnesses' constitutional right to a fair hearing under Article 28 of the Constitution of Uganda. Because what the petitioner is inviting this court to do is to condemn them, minus hearing them. Because the decisions of court are that you must listen to them. Before a decision is taken as to what circumstances, under what circumstances was there a recantation, if any. Because, my Lord, as we are going to demonstrate a few minutes from now, the three affidavits that the petitioner challenges are not all necessarily recanted. Your Honor, for example, we'll look at the affidavit of Ben Intale Mukasa on court record, which is the first affidavit that the petitioner raised to have this court expunged. My Lord, Ben Intale Mukasa is not a petitioner's witness. Ben Intale Mukasa is not a petitioner's witness.
So I understand for Ben Intale, but what about for Chiyemba Hassan,
My Lord,
and Maumbe George William?
my Lord, I'm coming there. Also right. So Ben Intale is not a petitioner's witness. Neither is Ben Intale bound by Section 19. That's Rule 19 of the Advocates Professional Conduct Regulations that counsel for the petitioner had cited. My Lord, as I come to the second and third affidavits, I would like to say that this court is equally faced with another appeal task. And that is balancing. That is balancing the obligation of an advocate under Rule 19, which was cited. That rule prohibits inducement, it prohibits tampering, it prohibits coercion, bribery, among others, of a witness by an advocate. My Lord, the court is asking, my Lord, Rule 17, I will quote it verbatim, places an obligation, it imposes a cardinal duty on each advocate conducting a case or a matter not to allow a court to be misled by remaining silent about a matter within his or her knowledge, which a reasonable person would realize, if made known to the court, would affect its proceedings, decision, or judgment. My Lord, I would like to submit, in concurrence with my colleagues, that the allegations raised by counsel for the petition are unsubstantiated as against the advocates, for instance, of the respondent. They are unsubstantiated, there is no proof, and in all the authorities that were cited, the Nalukoola, the Chintu Brandon, in those cases, it is the deponents of the two versions of the affidavits who had to come to court. And the guidance of the Supreme Court is that they must be cross-examined. In all those cases, some of which I happen to be part of, it's the witnesses that pointed out to court that no, it is the other lawyer, it is the other person.
What about these two? The two, Nathan and George? Nathan.
Most obliged, my Lord.
And the Mahumbe George. What about them?
Most obliged, my Lord.
Those two.
And those two,
Addressing on those two.
my Lord, my quoting of Rule 17 was introducing me to the two. For example, my Lord, Mahumbe George. Mahumbe George William, my Lord. Mahumbe George William, my Lord, is a very interesting. He's a very interesting. My Lord, the Mahumbe George William has deponed an affidavit. And my Lord is saying, Yes, my Lord.
So now let's have the two.
Yes, my Lord.
Yes, my Lord. Now that you have the two documents, you have one for the petition and you have one for the first one.
Yes, my Lord. My Lord, I would like first of all submit that the concept of recanting witnesses, as it is coined under our jurisprudence, is not expressly provided for under the laws of Uganda, like the word recanting witnesses. The akin to recanting witnesses is under section 153 and 154 of the Evidence Act. And those are the hostile witnesses. And how are they treated? My Lord, I will come there. But let me exactly go to Mahumbe. My Lord, Mahumbe is a very interesting witness. And Mahumbe is one of the reasons why the Supreme Court has guided that when court is faced with these scenarios, because they happen for so many reasons, before you even inquire to apply section 154(2), whether it is the opposite party that has bribed, coerced, induced, or done what, court must ask itself, was even the first affidavit, if any, acquired under any better terms? And that is the duty that the Supreme Court places. My Lord of page 22 is highlighted.
So what does it say?
My Lord, paragraph 4. This affidavit, if believed, says a lot about the way some witnesses are made to sign affidavits during election petitions. It contains very serious allegations about the appellant, and one would have expected the deponent to be subjected to rigorous cross-examination. He was not. Now, before court can be able to say which of these, because for example, Judge Williams, my lord.
So in this decision of the Supreme Court, was this also a case where the witness was on both sides?
Most of like yes, my lord. In fact, it's very material. But for Maumbe George, it's more interesting, my lord. And it would be very interesting to have the same person before court. Because it says, I never deponed an affidavit for the petitioner. I never at all met the petitioner. I never talked to the petitioner. Even on the voting date, I did not vote because I was not in the constituency. But this is a witness that has been presented by the petitioner. And my lord, how does Maumbe come? Maumbe comes through another witness, not through the lawyers. Because in Tale, Mukasa is said to have bribed Maumbe. When Intale is recording his affidavit, he's a leader, he looks for Maumbe, says, Maumbe, did I bribe you? Because there is evidence saying I bribed you. Maumbe said, which evidence? How come when I didn't vote? I was not even in Kawempe. I know, I'm willing to go to court and tell the court that I didn't vote and I've never sworn anything. My lord, that's the circumstance under which Maumbe comes. Now, the justice of the case is, should the court be requested to lock out such a person in an election petition, which is an inquiry?
Okay, the submission of counsel for the petitioner was not to lock out the witness, but subjective. There is already.
My lord, the prayer was
to strike out this second, and after that, we go to the first one, and then he is cross-examined.
My lord, my lord, from what we had captured, first of all, the right to cross-examine is available to all parties. And
the prayer was to strike out the second set.
Yes, my lord, and those are the affidavits we are talking about. And the law is that they are not struck out preliminary at this stage. And my lord, I will now go to the last one before I address specifically that issue, because the PO is premature. And we are going to submit about why it is premature. But I would like to go to the last one, who is Chamber Nathan. So my lord, on the first two, Intale Mukasa is not their witness, not subject to the PO. The second one didn't even swear. He's saying, I'm not recanting because I've never sworn. That one cannot also be called a recanting until court listens to me. The third, who is Nathan Moambuzi Chamber. My lord, this one is the one that falls under what we call recanting witnesses. Recanting witnesses. And recanting witnesses, I want to submit on that. Recanting witnesses are not illegal witnesses. My lord, in highlighting that, I would like to say that courts have held that in election petitions, like what we are dealing with right now, court is required to subject each allegation raised to a thorough and high level of scrutiny, and to be alive to the fact that in an election petition in which the prize is political power, witnesses who are invariably partisan might resort to telling lies in their evidence in order to secure judicial victory for their preferred candidate. My Lord, that's what we are faced with in the election petition. It is an extension of the campaign. The campaign not ended, there was a declaration, and a new campaign has begun in the court, where witnesses come with preconceived. So the jurisprudence of the country is that courts must examine each allegation. We are not allocating sainthood on the respondent, and neither are the petitioners. My Lord, your brother, Honorable Justice Isa Serunguma, in Kamwine Duffy versus Tumusibe Francis and 3 others, Kamwine Duffy versus by Bonus High Court Civil Suit number 96 of 2021, in citing the celebrated case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors, 1969 1EA, the court held, I will quote verbatim, for purposes of demonstrating to court that the criminal objection before court is not a criminal objection. It's premature. So far as I am aware, my Lord, that's page 6. Page 6 of the Kamwine Authority. And the second last paragraph is where I am. The court here noted that the question to be considered here is whether the preliminary objection raised is competent to be dealt with as such. The main principle governing criminal objection was considered way back in the case of Mukisa Biscuit, where court held that so far as I am aware, a criminal objection consists of a point of law which has been pleaded or which arises by inclear pleadings, and of which, if argued as a prior point, may dispose of the suit. A criminal objection is the nature of a demurrer. It raises a pure point of law which is argued on the presumption that all the facts pleaded by the other side are correct. And my Lord, my emphasis is on this last part. It cannot be raised if any fact has to be ascertained. My Lord, before us, court has no evidence, has no proof of any tampering, any bribery, any coercion, any inducement of any of the witnesses. So that is a fact that must be ascertained by one person like me, a lawyer, standing and giving evidence from the bar when I'm not a witness, cannot amount to proof before court, because these are very serious allegations that border on professional misconduct. So this authority, which has been consistently cited and is still binding, says it cannot be a PO if there are facts that have to be further ascertained through eliciting of evidence, or if what is sought is in the exercise of judicial discretion. Now, what counsel for the petitioner wants court to do is exercise discretion between these two sets. Which one? My Lord, that ceases to be a PO. And we are submitting, my Lord, that the PO is not a PO and should be overruled and dismissed with force. The court be pleased. My Lord, the law provides remedies in these instances. And the remedies is what has been applied consistently, even in the authorities that is cited. As to whether the recanting is real or not becomes an issue for determination. And then evidence is led. And when court is finally determining, guided by the nature of evidence before it, it takes a decision judiciously. However, with that, I conclude by submitting that this court be invited to follow the binding decisions of the Supreme Court, which are stare decisis, in answering the question before it. In answering the question before it. And for brevity, my Lord, you sit on the bench, Justice Farida Kirwa, in Uganda versus Sengonga Musa. In Uganda versus Sengonga Musa, in which she cited the Supreme Court decision of Okwanga Anthony, in which he cited the Supreme Court decision of Okwanga Anthony versus Uganda, Supreme Court, Criminal Appeal number 20 of 2000. In answering the question as to whether the evidence of the hostile witness, my Lord, these are hostile witnesses in law. One who does this and tries to change a position are hostile witnesses. And hostile witnesses appear every day when you are in court. You cross-examine the fellow and he runs from his other position and changes and say, I'm now ready to say the truth. That is not illegal. It is in fact kudos to lawyers and court for doing the right work to make justice out of whatever situation is before you. Court says here, go to the Supreme Court. My Lord, it is on that authority that we shared with court. It's highlighted. And it was held that it is a settled legal position that the evidence.
Where are you reading from?
My Lord, page 3. On the decision of Segonga. Hostile witness does not find what the court there was quoting. It is going to mean testimony of a witness standing to depose in favor of the opposite party. We must bear it in mind that the witness may depose in favor of the party in whose favor it is meant to be given through his examination in chief, while later on change his view in favor of the opposite side. Similarly, there will be cases where a witness does not support the case of the party, starting from the examination in chief itself. This classification has to be borne in mind by the court. With respect to the first category, the court is not denuded of its power to make an appropriate assessment of the evidence. Such evidence would become complete after the cross-examination. So once evidence is completed, the same testimony as a whole is meant for the court to assess and appreciate what facts. Therefore, not only the specific part in which a witness has turned hostile, but the circumstances under which it happened can also be considered. My Lord, just quoting also that the reason why the precedents have encouraged when those occurrences arise to subject the parties to cross-examination is for court to appreciate the circumstances under which the incidences do arise. My Lord, with that, we would like to pray that court be pleased to overrule the objection because it is premature and the law provides for remedies on how to deal with the same situation.
Okay, before I proceed, what about the recent Court of Appeal decision, 2024? I think Attorney Moses was cited by Counsel Nalukoola. You address me on that decision. Because
My Lord,
it's the honor of we are now 2025 last year.
my Lord,
It's a recent decision.
yes, my Lord. And my Lord, we want first of all to associate ourselves for the respondent with the same decision and invite court to follow the same decision.
What does it say?
My Lord, we will go to page my Lord, in the same decision, court was of the view that a decision on how to treat the same can only be arrived at after evaluation.
Yeah, I want you to go to the judge. What the judge said. I think it was just the same word and then.
Also, my Lord, let me get the Court of Appeal decision on that. My Lord, I don't read it here, but the frowning at the practice of lawyers was arrived at after a judicial inquiry, after cross-examination. You cannot at a preliminary stage say, for example, a lawyer influenced, a lawyer did this. In fact, in all the authorities, even in Atan itself, the witnesses are subjected to that process. And my Lord, just like I had highlighted, there is Supreme Court guidance on that, how we deal with them.
What should the judge say about how a trial court is supposed to deal with some specific guidance from the judge?
My Lord, just a moment. My Lord, I would seek guidance on any specific page that you will be directing me to.
My Lord, it's page 17 for quick assistance. Page 17 and 18. Paragraph 58, 59, and 60.
Yes, my Lord. So, page 17 is there are two possible approaches to dealing with affidavits of witnesses that switch sides and or recant their earlier affidavits. Firstly, it is wrong and unprofessional for an opposite party to approach the witness of the other party seeking to turn the person into a witness for his side. And my Lord, that is a statement of fact. My Lord, I say it is wrong, but I'm also saying here, I'm interpreting this, that this is a statement of fact, because evidence had been led to that, even in the law court, by witnesses. And in this instance, my Lord, we are not going to treat counsel's submissions from the bar as the evidence.
Did you read the bit about how the trial court should have dealt that?
My Lord, once my Lord, first is wrong, then once that party is aware that person is a witness for the other party, the only option available to him or her is to meet in court and subject such witness to cross-examination. Well, this is the decision here. Although I'm saying that there is a Supreme Court decision and we have a principle of stare decisis, and I've quoted that authority and given it to court. But in the wisdom here, there are options that are available. And that is Bakaluba Mukasa Peter, which is Supreme Court, on how to treat. And my lord, it was page 22 that I earlier highlighted, support. Yes, my lord. The deponent has to be subjected to rigorous examination. Even before you reach the decision and the advice that the Court of Appeal is giving by Justice Godantende, you must have subjected this deponent. And by the time you arrive at a finding, whether there has been unprofessional conduct or what, is after a due process. And that's what the Supreme Court authority says. And my lord, the Supreme Court was speaking from the case of Nelson. Nelson versus the Attorney General and another, 1999, East Africa. My lord, it was unnumbered, but there is page 3. Where court, the Supreme Court, says evidence by defectors must be received with caution and should only be admitted in special circumstances. So it doesn't say that evidence by defectors acts like a Russian poison. Don't touch, don't see. No. It must be received by caution. And if it is to be admitted or relied upon, the Supreme Court still in Okwanga Anthony, which I've cited, guides how court. Because between the two sides coming before court, we don't know who is right. It is for court to determine who is right. So before you are no angels, my lord. I beg to submit.
There is also the decision of Mukisa.
Introduce yourself.
But for the record, review of it. Not on the issue of the nature of the people, my colleague did into the decision of the Supreme Court decision on the Mukisa dispute manufacturing. We have supplied the copy to our colleague. This is the copy of court. But my lord, the issue of recanting evidence, which my lord, in our view, has been settled by the Supreme Court. The decision of Nelson that has been quoted by my colleague Nelson versus the Archbishop, the decision of the Court of Appeal in Kenya, Tanzania, my lord, sorry, which was also determining a similar situation. And my lord, there had been several recanting witnesses. My lord, in determining that issue, court was faced with two scenarios. One is, do you expand from the record such evidence of a recanting witness? And two, what then do you do with it? My lord, in deciding that decision, the court quoted the decision of the Supreme Court of India, that is Khan versus Ahmed, 1975. So my lord, this goes to show that the phenomena of recanting witnesses in election processes is not new. In 1975, the Supreme Court of India also decided the same decision, and the holding in the Supreme Court of India was that if you have such defecting witnesses, one, allow their evidence on record, but in assessing, which is the role of courts, you now have to weigh under what circumstances did they make the first evidence, and what are the extraneous circumstances did they recant the evidence that had already been on record. And my lord, that is the holding that the defector's evidence cannot be rejected, but it must be received, and the court has to deal with it with caution. With caution, my lord. My lord, the respondent, the petitioner also had alluded to the decision of Mbaju. That I think is the decision of Justice Egonande. And my lord, when you look at the reasoning, it all stems from Nelson, and then Bakaluba Peter Mukasa, and then it has to flow like that. So it had already been determined that how do you then deal with it? My lord, in Bakaluba Mukasa, Peter, the court said that the only reason why you would close out an affidavit that has been recanted is one, if it has not been deposed before a commissioner of court. So that would then be a preliminary point of law, that in as far as the law of affidavit is concerned, this affidavit does not squarely fall within what would be acceptable by court. That is one. My lord, in as far as we understand the PO of the petitioner, that is not the case. The case is that the affidavit was properly sworn. Our only problem is that it is recanted. And the Supreme Court has guided that in cases where you're faced with such a situation, that witness must be brought and put to stand and rigorously cross-examined. My lord, amongst the other decisions that was the decision of Atano here, which I referred to. My lord, the judge also should be page 20. But my lord, you already have it. The judge, in all determining all this decision, Chintu, Brandon, Nalukoola, said that the role of determining whether or not, or what weight to give to the evidence of a recanting witness is with court. And that, my lord, implies that you first have to allow the evidence on record, and then when you retire to determine this matter, assess which of the stories do I go with, and under what circumstances do I say this has more weight and this does not, my lord.
That's very decision to our own. Paragraph 59. Read the paragraph.
Paragraph?
That's 59 of the attorney Moses.
My lord, I don't know whether the one I have is numbered. It's not, my lord, the one separated is not. I think, my lord, you were talking about in budget. Yes, but my lord, what in other words, my colleague, you conclude. I would say it is not a question of either or.
59.
59. The land trial judge ought to have struck out the second set of the 12 affidavits sworn by the persons who had already sworn affidavits in support of the petition. The persons were approached by the respondents, counsel, and made to swear affidavits recanting their earlier sworn affidavits in favor of the petition. The respondent was barred by law from approaching and talking to. Yes, my lord, I don't know what. But my lord, this paragraph, if I may, this paragraph has very unique approaches. One, it alludes to that the respondent stands to approach. Approach is born of evidence. You must first prove that the lawyer approached the witness, either coerced, coalesced, or forced or induced them to give you evidence. My Lord, that is missing in this case. That is missing in this case, unless my Lord court would be receiving evidence from the back. My Lord, that is one. But all the elements in this paragraph, my Lord, are that these things must be born of evidence. And the evidence has to be either by a witness himself saying that, for instance, Alex Uganda approached me, promised to buy me something, and then that is how I gave evidence. But my Lord, the point we are making really is that this is a court of appeal decision. And our arguments are on the basis of the Supreme Court, which says that, one, call that witness, cross-examine them, and find out what are the extraneous circumstances under which they are recanting their evidence. Because, my Lord, in an inquiry of this nature, I think that would be pertinent. My Lord, lastly, which is what I already alluded to in the case of Nelson, which I have supplied to court. When, my Lord, you retire and you read that case and the quotation or excerpts from the decision of the Supreme Court of India, they have been called election tangles. That is the point, that election tangles. And my Lord, the background to that was that in election processes, these things should not be treated as strange, because they will not stop in this petition, they will happen in petitions to come, but how do you deal with them? The Supreme Court, as early as of India, as early as 1975, had already determined that that witness has to be brought, and then the court would be interested in understanding how did you shift from the earlier position to this position. Because, my Lord, in the decision of Nelson, the recanting witness had actually been part of the party. It was called Mapena, and was part involved in even in the electioneering activities. And then when they came to court, he recanted, and court was they are faced with the situation. How now do you deal, for example, with the Secretary General of NRM giving evidence to National Unity Platform? Court said, no, we are not aware of the circumstances under which that person changed their mind. So it is important that we call them to court, cross-examine them, and then after cross-examining, we shall be able to see how to treat this evidence. So that, my Lord, is the jurisprudence as we know it. Until the Supreme Court, my Lord, determines and says, well, you have to take this approach. The approach is that you have to call those witnesses and they come to court, cross-examine so that court can make its informed and erudite decision as to whether and how they regard the evidence. My Lord, I take submission. My Lord, also, for the record, my Lord, we have the first respondent in court, Mr. Nalukoola, Limbazi. I don't see the petition. Petitioner.
It's too far.
Yes, my Lord, Samuel Mulindwa.
Lord, I raise the point that they are dealing with premature. And probably that is why we are finding it difficult in taking home some of the points they are raising. My Lord, we are proceeding under presumption that the affidavits have been admitted. My Lord, the practice that we bring in at least Rule 15, if you look at all these decisions, my Lord, we used to actually, when affidavits are before you, my my Lord, they would first be deemed read before we even proceed. My Lord, in the current situation, while I believe they are premature, may lead to a miscarriage of justice, is you realize even the directions to this court on how a hearing has been conducted. There is even space for the petitioner to withdraw the evidence of a witness who is saying, I never saw any affidavit. Now, if you looked at the directions for hearing under Rule 9, nine of the rules under the Parliamentary Elections Act, my Lord, you realize that the process we are miscarrying the process because upon presentation, the petition, serving the petition, the judge, with consent of the parties under 2, will hear the parties on whether any of the parties can withdraw. That is subregulation 2, paragraph A. You may receive a written notice of an intention not to oppose. You may receive written notice that the petitioner wishes to withdraw the petition. My Lord, you may record any facts which have been agreed by the parties. It's a process. After recording the facts, my Lord, you may settle the remaining issues, if any. My Lord, after that process, you give directions as to further and better particulars, which may be necessary to avoid surprise at hearing. Most important, my Lord, you may give directions as to the evidence to be called at trial, and on whether witnesses should testify by affidavit evidence as the examination of chief of a witness with oral cross-examination and re-examination, or by documentary proof, and whether the case will be had ex parte. My Lord, we have jumped. Before we've done all this, before even pleadings are closed, most important, before pleadings are closed, we are now jumping into even discussing matters. There's a scenario. We are even in the merits. My Lord, the spirit of the decision of Muksa that has been cited, you'll find in the ratio somewhere that even if you raise the PO, my Lord, on page 6 of the decision which cited, that is Amwene Dafi, you'll find that court say that it raises a pure point of law which is argued on the assumption, my Lord, that all facts pleaded by the parties either side are correct. My Lord, we still have facts coming in court. I deem it that affidavits are part of pleadings. My Lord, it would cause a miscarriage if at this stage we went into detail to know that strike out these affidavits or not. My Lord, we stand also, we stand a danger. If the ruling on these POs is to come at a later stage, my Lord, probably we had more recanting witnesses. Yes, probably we had more. Okay. So it would be difficult on whether to bring in other people who are saying actually, we did not. So I believe my point, the point, my Lord, is we are dealing with the premature, and this is an inquiry that is submitted. My Lord, in the case of Honorable Mama Babas, the Supreme Court determined that petitions of the nature are an inquiry. At this stage, you can't start closing out any evidence before you even inquire. We've not started trial. Before an inquiry, we are jumping. Now, that was in Amama Babasi versus Yori Kakuta Museveni and others where we participated with our senior colleague. We took there's a lot of literature discussing on whether that's election petition number 1 of 2016, of the nature of an election petition. And the finding was, it was an inquiry. An inquiry is like an investigation. In an investigation, you don't simply close out any information. And that's what supports the then submission of my colleagues. I submit that you find, my Lord, that their criminal point of law is premature. It should be overruled. It may cause a miscarriage of justice and a mistrial in this hand. I so submit. And we are I'm obliged, my Lord.
My Lord, my colleagues are able to put the points of law to you.
Yes, my Lord, of course I do. The very interesting arguments of my colleagues. They are littered by misconceptions and misunderstandings of what my preliminary objection was about. Let me start with, my Lord, the decision of Nambi. Now, my Lord, I have read that decision. And while my colleagues were submitting here, I got the feeling that we're reading from a different script. That decision, my Lord, is inapplicable to the current circumstances. Why? Number one, the Supreme Court did not, that's why I kept asking, did not specifically deal with the issue of recanting witnesses. It's not there. And they have a different decision than what I have. And it did not make a decision on the issue of recanting witnesses. They are quoting a decision by implication. Secondly, my Lord, that decision did not consider anywhere Rule 19 of the Advocates' Professional Conduct Regulations. It's not there. Unless again, they have a different script. Thirdly, my Lord, even if that decision had taken into account those two principles, the current decisions of the Court of Appeal would be the correct position of the law, and I'll tell you why. The current decisions of the Court of Appeal would be the correct positions of the law. The decisions as late as at hand. Why, my Lord? Because of the doctrine of concurrent or coordinate jurisdiction. My Lord, under Section 85(3) of the Parliamentary Elections Act, the Court of Appeal is the final court of appeal in parliamentary election matters. It would mean, my Lord, that decisions of the Court of the Supreme Court that previously was the final court of appeal, and those of the Court of Appeal now as the final court of appeal rank at the same level under the doctrine of coordinate jurisdiction. My Lord, for that principle, I rely on the decision of Young versus Bristol Airplane. Young versus Bristol Airplane Company Limited. 1944, Volume 1K. That decision, my Lord, what I'm quoting, has been quoted in several Supreme Court decisions of Uganda. I'll submit to you, my Lord. Fourthly, my Lord, that is why that decision that I've just quoted of Nambi was referred to in Kintu Alex Brandon on this exact subject, and the Court of Appeal took a different approach. I'm sure Mr. Alex Brandon knows
since he says the attributes. They considered that decision, my lord, at page 11 up to page 12 of that decision. They looked at it, they found it inapplicable in the terms I am proposing. Question number 2. Is this a people? Is this premature? Is this a premature? My lord, it is not. And my friend's submissions on that point, I think, and because of the misunderstanding of what the people is. This people is simply that there are 2 affidavits on record. There is one in support of the petitioner and another in support of the first respondent. That is a fact that needs no further evidence. Point number 1. Point number 2, that the lawyers, my colleagues for the first respondent, have assisted these witnesses in preparing, understanding, explaining, translating, and these affidavits, filing these affidavits on court record is not in dispute. Because they say so in the affidavits, my lord. They say, I have been helped by the lawyers. I have been helped by the lawyers. Those paragraphs are there, my lord. And you see them in the affidavits of Maumbe, Mukasa, and Chen. That fact, my lord, is not in dispute and needs no further proof. And that is the nature of my people only. I am saying you cannot have 2 affidavits on record. As simple as that. And those 2 facts need no further proof. Corollary to that, my lord, I think I should also say this in passing. The submissions of Mr. Meese. My lord, pleadings are closed. I'll give you the decision he argued himself. Pleadings are closed. Some of you argued this decision, but you are forgotten. Kind of recent before. Versus Linda Fabrics. My lord, pleadings are closed when the answers are filed. This is the
Of course not.
My lord, when they talk about the facts in Muksa this week, I have just told you the facts that constitute my people. My facts are only 2. One, that affidavits are 2 affidavits from the same people appear on the record. That's the fact I am filing. They went into so many other things, but this is my fact. They went into many other relevant things. The second fact is that these affidavits were prepared, filed, translated, explained by my colleagues. That one needs no further proof. My lord, these two facts I'm talking about were prohibited in all of the authorities I cited. Whether it is Chintu, whether it is Baju, whether it is Akan, whether it is Nalukoola, the court of appeal is simply saying, don't touch. Okay? Don't bring second affidavits. Now, my lord, at that point, they then came into what I'm submitting. They are saying, you can cross-examine. You can cross-examine. It is okay. That's what I am saying. That the approach is not for you. When you hear all of these things they have been saying, did I bribe? Did I induce? Did I do what? It is okay. Those things do not come to the record by way of a second affidavit. No. What the courts have told you, you wait for cross-examination, which they have extensively alluded to, and then you bring out all of those facts. Okay, you do not bring them by way of a second affidavit. And my lord, on the question of hostile witnesses, witnesses don't become hostile in lawyers' chambers. That's section 153 that my colleague referred to. A witness becomes hostile when he has been asked a question and he is answering contrary to the witness, the party that brought them. You will not sit in your chambers in Mengo and say this witness is hostile. I must take him to court. No. They don't become hostile in lawyers' chambers. They become hostile here in the dock during cross-examination. Which is what I'm telling you, which is what the court of appeal has said. That is the approach. Take out the second set of affidavits, let the witnesses come to court, and they undergo all manner of tests through cross-examination by the court and by the other party. So all the things they went into, there is no proof of bribery, inducement, all those ones are not my PO. All of those facts they will hear during cross-examination. My question is, you have 2 affidavits on file. The Court of Appeal has said the second set must go. Then what do? You do what they are saying. Cross-examine extensively, test veracity and reliability in cross-examination, not by filing a second affidavit, Your Lordship. My Lord, Mr. Uganda alluded to the fact that Maumbe says, because Maumbe says he never signed an affidavit. All that comes in cross-examination. Okay? It's when you find out, did you sign an affidavit? Says no. Did they approach you? No. You don't make them swear a second affidavit. You establish all of those claims during cross-examination. My Lord, in one of the students I gave you earlier, that's what the Court of Appeal says. I'll take you there, briefly, my Lord, if I may. This is my Lord Obonama that you have already there. Just access mine here. Lawrence Onama Obo. My Lord, at page 13, paragraph 29. This is what the Court of Appeal says. Therefore, if he believed that the deponent had indeed been coerced into deponing an affidavit against him, the course of action that was available to the first respondent, just like Mr. Nalukoola here, was to subject Mr. Wahadira to cross-examination to establish the veracity of his claims. Now, the approach is not file a second affidavit. You do as they are acceding. You cross-examine. You don't file a second affidavit. My PO is that you have 2 affidavits on record, and the Court of Appeal has said no. Take out the second set. Then deal with the rest of the issues. I can give you situations that was. Yes, you can get it. For now. Now, my Lord, the issue of witnesses are free to become hostile. They are free to recant. This recanting has been there for ages. First of all, yes, it has been there for ages, but the Court of Appeal has told you it is illegal in Uganda. Clear. Okay, in all of the decisions I have cited, the Court of Appeal has told you it is illegal in this country. So it doesn't matter whether it has been here for ages in India, Tanzania. This court, this country has told you recanting is illegal in no uncertain terms, and that the other party is barred by law from approaching the witnesses of the other side in no uncertain terms. Now, whereas, my Lord, witnesses may change testimony. For example, in cross-examination, I bring a witness and says weird things. Whereas counsel cannot control what a witness says in the box. There is something a lawyer can control, my Lord, which is the central point in this matter. Where a witness says, I want to say something else, I want to recant, that is right. But there is something a lawyer must do. These colleagues of mine ought to have known. When clients came to them and told them they want to recant, they ought to know the law. They would have told them, wait, during cross-examination, sirs, we shall handle that matter there. Okay? That is what Chief Alex Fredo says that Mr. Uganda argued. It says they ought to have known and told the witnesses that, please, yes, we have heard you did swear, you were taken to Kololo and everything else, but wait, during cross-examination, we shall handle that. Because my colleagues know the law that the Court of Appeal has told you, don't file a second affidavit, wait for that witness during cross-examination and ask all manner of questions. That the lawyer has no right, my lord. In fact, it is an obligation to tell the client, please, let's not take this affidavit here. For that, my lord, I rely on the decision. That kind of lawyers, I like the decision of Myers versus Elman. House of Lords, same situation. What did the House of Lords say, my lord? Because last time someone was saying, what if they insisted? What if they insisted? The House of Lords said, the solicitor, I'm reading verbatim, the solicitor cannot allow a client to make whatever affidavits he thinks fit, nor can he escape responsibility for careful supervision and investigation. If the client will not give him the information he is entitled to, or he insists on swearing an affidavit, which the solicitor knows to be imperfect, like in this case under our law, my lord, what does the House of Lords say? The solicitor's proper course is to withdraw from the case. That's the same situation. I've highlighted other areas that are clear in this point. So it doesn't even arise that as the lawyers, we are not the ones who approach. The law bars even Mr. Nalukoola. And I told you, my lord, last time that is interesting. If you look at those affidavits, they were all translated by somebody from Mr. Nalukoola's law firm. And the court of appeal has told you, whether you are the respondent, whether you are the lawyer, you are bad. Don't touch the forbidden fruit, as Justice Abundant and calls it in our country. So, my lord, it cannot even obtain in this argument that Rule 19, we have not moved lawyers in use for that. No. The prohibition is against both the first respondent and the lawyer. The prohibition is against both the client and the lawyer, my lord. Now, on the issue of how do you approach this scenario, my colleagues have gone to a great length, call them to tell you whether they were bribed. But, my lord, Atan has told you, okay, and I have argued that under the doctrine of concurrent or coordinate jurisdiction, that issue is at the same level as the numbers, even if it had said something else, which it doesn't. Atan tells you, your lordship, that what you do when you are faced with this scenario, kindly strike out the second set of affidavits. None of the decisions, my lord, I have quoted to you from the Court of Appeal, including Atan, tells you that first listen to them. No. None of them says that. No, not single one of them says first listen to them to see what they are saying, then strike out. No. It tells you, once you see two affidavits, strike out the second say. Then let the witnesses come to the box. Okay? Because, my lord, it is not only through a second affidavit that this evidence my colleague is referring to is the only way it can be received by the court. No. It is not through a second affidavit that the evidence you are talking about can be received by the court. It can be received viva voce through cross-examination. So, my lord, what the point I'm saying is that the concept of a second affidavit doesn't appear anyway. And it's not the only way that all manner of evidence they are talking about to prove whatever they want will come to the court. It can come to the court and it will, and the Court of Appeal has told you it will come through cross-examination, not any other way. The affidavit on Kasantari, my lord. I think my colleagues misunderstood my objection on that point. I did not say Mukasa recanted. I only said that Mukasa procured the commission of the illegality we are dealing with. There are two persons who recanted, Chamber and Nathan. Okay. Chamber James Mwangzi and Nathan. For Mukasa, my argument was that if the court is convinced that this was an illegality, he clearly, and the deponents clearly say he is the one who brought them into the illegality. I am saying, whoever says of having participated in that illegality was out of state. And I've introduced that illegality to you, and my lord cannot ignore it. International. Now, my colleagues have also referred to a couple of decisions of the High Court, and that surprised me a bit. And I don't want to. My lord, I don't want to take my colleagues on the study of the doctrine of precedents. But when we are here discussing Court of Appeal decisions, I didn't expect High Court decisions. Now, my lord, in Paul Kawanga Semogene, just know that way in Kawanga Semogene, versus Attorney General, even if this court had an opinion different from Atan, different from Brendan, different from Nalukoola, it cannot take it. In Semogene, the Court of Appeal disregarded two decisions of the Supreme Court on the same matter. The lordships of the Supreme Court said the Court of Appeal was not entitled to do that, even if it had a different opinion. So this decision of the High Court, those ones are out of state. Even if my lord held a different view, when Alex says do this, that is, when Atan says do this, that is, even if you want a different opinion, my lord. And that matter that I've just referred to also was captured in Young versus Mr. Elway, the same point. So my lord, we have made decisions from the Court of Appeals that are binding on the court on how to approach this matter. And I've distinguished and I've taken away the decision of numbers, and even if it were there, it would be acceptable. So really, we should not be entertaining decisions of the High Court. I'll give you the decision about that. My lord, this issue, we shall handle the people later. We shall handle the people later. Why? Points of law, my lord, are taken at the earliest. And my lord, there's a decision here. I don't know if I have it in my file here. In election petitions, you take it immediately. I'll refer to it, my lord. I remember it in my head. It is Serapiu Okun versus Attorney General, 1997. It says when in an election petition a people arises, you immediately deal with it. To avoid, they say in that decision, confusing issues. So let us not confuse issues that my colleagues are saying here. We first hear who bribed them, whether they were coerced. The second affidavit is here, take it out. All those other things we shall hear in cross-examination. Counsel referred to Rule 17 of the Advocates Professional Conduct Regulations. Rule 17 does not allow you to file a second affidavit. It does not allow you to file a second affidavit. He tells you, yes, you tell court what happened. So you tell court that Nambi was bribed or coerced. That's fine. In cross examination, not by you filing a second affidavit. You still have the duty, even during cross examination, to tell court what happened. Okay? But you do not file a second affidavit. So that rule does not permit you to do. Mr. Gunn again saying that recanting is lawful in this country. It is not. The Court of Appeal has told you it is not, and I've already dealt with that point. With those submissions, my Lord, I pray, I reiterate my prayer that the second affidavits of Chairman and Mwamuzi and Maombe Williams be struck the second set. Then, my Lord, subject those two witnesses on the basis of their affidavits in support of the petition, a thorough scrutiny, a credibility test, a reliability test in accordance with the decisions I have set here. For the affidavit of Ben Mukasanga, my prayer, my Lord, is that for him having procured the commission of the inquiry we are dealing with, that we struck out for that reason on the basis of Makula International.
Before you see,
Yes,
Maombe George, I see
yes, my Lord, we saw that the affidavit is it was an inadvertent error. But my Lord, the authorities of the Court of Appeal at the Supreme Court, Saga versus Master Cycles, Castle versus Supreme Court Justice Okero, said those are my issues. For the absence of a date is a minor issue. Saga versus Master Cycles and Castle. My Lord, I don't have them here, but I can cite them to you because it's in my head. Saga versus Master Cycles, the Court of Appeal decision, and Castle versus it is a Counsel Growers versus Supreme Court Justice. Okay, I can provide them later. The fellowship saying answer my question. I will reply.
So the decision on the appeal shall be delivered on Friday, 9th of May, at 9 a.m. Thereafter, the court shall conduct a children's conference for the petition. So Friday, 9th of May at 9.
Notice of the petitioner update. What should take
tunnatuuka kutunula mu ffe boolaba twakwatanga ensawo z'abasiniya tuyige
You are quoting our authorities. Fetumanyi what happened.
kakabeere kalula awozizzamu
kirabika Nalukoola baagala beeremu kizibu bwe mukoze tambula
n'essimu nga bukyali kano kayinza okuwuula
all the decisions they were quoting his previous cases. And then you see how he ended up corrupting.
Sit down with you. Sit down with you.
Allah.
olwaleero ensonga ezateekebwayo bannamateeka ng'oyo atidde okujja mu kkooti ate yawaaba omusango guno sobodde okuddamu ensonga zaabwe ez'okugamba nti abajulizi baffe abajja ne bawa obujulizi mu kkooti eno nti tebawangako Nambi bujulizi waleeta petition ye mu kkooti nga ye agamba bwe babagibwa tusobodde okuteekamu ensonga zaffe eziraga lwaki kkooti tesaana kukugirwa kutunulira ku bujulizi obwo. Ekisinga byonna Supreme Court yalagira dda nti zino ensonga z'ebyokulonda teziba zaffe, ziba z'Abannayuganda. Kyekyo lwaki ebeera inquiry kuba kunoonyereza. Kaakati Nambi kyali mugamba kkooti nti abajulizi abajja ne bagamba nti basayiningako ku mpapula za Nambi, ali mugamba abajulizi obujulizi bw'okwogera ekyo kkooti erina kukola ki? Kutunulamu. Ekisooka agireese ku budde obutali butuufu, kubanga ekirina kujja batandise kuliiza musango. Katuyingidde ebintu ebibizaabuza okuba nti nno tulinga abatandise okuwuliriza omusango tutanaba na kushedulinga, tutanaba na kusalawo kutambula kutya, tutanaba kusalawo bujulizi ki obulimu n'obutalina kubaawo. Tulowooza nti ekyo si kituufu, naye obuyinza buli eri kkooti ku lwokutaano okusalawo webegenda kutambula bweti. Naye bwe kujja kuba kusoose kkooti yonna mu nsonga za kkooti mu musango gw'ebyobufuzi nga guno gwa election petition okutandika okuwuliriza omusango ate naba nakukola kye bayita scheduling conference. Tetulowooza nti kijja kuba kino. N'ekisinga okuba ekikulu tituli beeteefuteefu. Babaagala bali babaleete tubasoyeso ebibuuzo ku budde bwabwe, naye ate tubuuzo naleeta ati omuntu agamba sibangako mujulizi wo. Kwabo bagamba nti oyo omujulizi agamba nti si mujulizi waffe, wandimulinze ne tumala omuyita n'olyoka omusoyasoya ebibuuzo ebikakasa oba mutuufu oba nedda. Omuntu akugambye nti si mujulizi wo, tamanyidde ofiisi yo gyeri, talayirangako kirayiro kikuleeta mu kkooti, kati onaleeta muzimu gwe. Ndowooza ezo z'ensonga zitulinze ku lwokutaano. Omulamuzi atubuulire oba batambula bulungi, oba abajulizi abo bagibweko kaakati, oba balinde basoyasoya ebibuuzo kati tayimu yakyo etuuse nga omusango gutandise okukola ki? Kuwulizibwa. So basically difensi yaffe nti emisango gyonna gye tubaddemu gigamba nti abantu nga bwe batu terina bagoba ku siteegi, erina okubawuliriza. Kyekiri kyenjogedde nti kkooti ensudduumu yagamba omusango gwa Maama Mbabazi nti eno ebeera inquiry kuba kunoonyereza, naye ate onaanoonyereza otya nga abajulizi abaleeta obujulizi obagobi? Tugamba nti kkooti terina buyinza okuba mujulizi yenna ajja mu maaso gaayo okwogera ku nsonga z'ekawempe, erina buyinza bwabulizi. Today we made our response and reply to the preliminary point of law objection by the petitioner, who is seeking an order of this court to strike out the affidavits of the respondent, specifically of those who deny being witnesses of the petition. We have witnesses who say, whereas we are aware that there are affidavits on record which were not sworn by us, we do not know the lawyers who prepared this petition, except for knowing Nambi as a candidate in the election. We are not her witnesses in this matter. Now, Nambi and her lawyers are saying those witnesses who are denying us the evidence should not be given an opportunity to speak. Well, clothed with the decisions of the Supreme Court, we are telling this court that this is an inquiry. Actually, these witnesses cease being their witnesses because they cannot even withdraw this petition without leave of court. They only have leverage within the law to withdraw that evidence. I would beseech them, if a person came and saw an affidavit with this signature, which is actually relating the signature of their ID, the right thing to do is to withdraw the evidence that has been denied by him. But now we've gone into a trial, we are going into issues which we've had. Besides that witness having said they never signed, the affidavit is even not dated. Besides that, it is not commissioned. So it is no evidence at all. So what he's saying, remove the evidence which has fully been signed, attested to, and leave evidence on record which is not dated, which the witness is saying, I never signed, I never swore to. We are waiting for the court. We may not go into the merits of what will happen. We are waiting to see if the court determines that such witnesses should not be heard. It would be against the cardinal rule of the right to fair hearing, where you deny evidence to come on record in such a matter, where you are duty bound to inquire about the investigation. You cannot carry out investigations when you are locking out potential witnesses who have evidence. So we are waiting for a ruling on the 9th, determining on how to proceed from here. But we are ready in any case. Whatever the decision, we are ready to defend the rights of the people. However, the Honorable Nalukoola.
And maybe fundamentally, if you have nothing to hide as a petitioner, then you should not fear witnesses coming on court. That's what we're saying. Oba tolina kyokweka kyonna kyonna ng'omukweya waaba omusango tolina kujja julite nalina kujja mukola ki waba mukozi era ffe gye tusaba tukotekirize buli omu azze nga alina kyayogera emuwulirize beemekula okusala okwali.
You have heard from my lawyer. What more should I say? Nambi filed a very frivolous petition like I alluded the other time. Indeed, she's inviting court to handle a very minor issue which will suffer. There is a rule, the minimis rule. Yes, courts are not concerned about such minor issues. Now her lawyers are bringing out minute other issues to waste our precious time. And indeed they want to build on that, to show the world that they have something serious here. But there is nothing. It's an empty petition, brothers and sisters. It is meant to waste our time. It is meant to make the people of Kawempe North constituency suffer. I would be now representing them effectively, but we are here defending incompetent petition filed by Nambi. I don't know why. But several never nyabo bana Uganda abalungi abali. Muchala Nambi yaleta akantu akatali namakulu ng'akiyita petition. Ate kakati atuzza mu buntu obutono ennyo. Abajulizi akakabaka ke, abaperereza bamwegaanye mukazi wattu. Oba ye yalagawa ate agaanye n'okujja mu kkooti awuze omusango gwe bwe yawaaba. yanjozaayoza nze gwe mulaba e Kawempe North ewambogo n'agamba Nalukoola wampangudde n'atuuka n'okuwa ensonga n'agamba naye bw'abadde tojja kumpangula lwakuba abajja ati baakukuba ne neewuunya lwaki teyagamba bakadde be kumusindiikira ku jjaati mukubamu alemesezza abantu b'e Kawempe North Constituency okufuna obuweereza obulungi okubakiikirira mu ngeri ennungi kuba kati entebe ngituddemu makiikakiika bw'ataafuna bululu bwagenda awaaba emisango egitalina makubo egitasobola kuwangulwa balooyawo bali mu buntuntu bazannya wano jangu okwekule bannange bano tubasobola bassebo ne bannyabo saagala mubeereyo nga mweraliikirira bannakawempe North mukyala Nambi ebintu byalimu tebitegeerekeka bakulida bange bamaze bagamba ensonga n'omulamuzi aziwulidde nkakasa omulamuzi oyo ajja kutagandula ebintu ajja kuwa ensalawo oyo abagambe bemwogera bya butali bali mu byakandolindoli omusota gwattende wali oyagala kutte mulaalo bwendera ewunya amalu byali wunye mwebale nnyo mwebale ddala
Okay, ndowooza leero katukoma awo badiya tujja kuddamu enkya tujja kuddamu Friday inshallah. So yoyo Nalukoola Elias abantu b'e Kawempe gwe mwalonda. Kanta. Kyambadde oli mugenda wangambye ogenda conference nze era obwedda mmanyi tetuli naawe baawe baawe
naye nga bwogambye tubasula